Is the union of church and state inherently a bad concept? And what were the issues when they joined together? We know about the Islamic way of life called Sharia law, Sharia, when the state joined with the Islamic religion. Some Christian countries have a Christian way of life based on God's laws, somewhat like Sharia's role in Islam, but most are separated from legislative mandates. Before Christ's ministry, God gave control to the government of most Jewish states and Israeli believers to enforce biblical laws. However, with the introduction of Christ's ministry, humans have the free will to obey or disobey God's spiritual laws without punishment to be inflicted by government laws. That is why the religious people escape from Europe from the Catholic and English persecuting powers of a church and state union and flee to the Americas. In the initial state, the tendency was to continue the norm of having the church way of life be regulated by the ruling U.S. colonies. However, the Constitution of the USA was later amended with the First and 14th Amendments, which is to separate religious consciences from that of civil affairs. It seems like the authors of Project 2025 wants to bring back a church and state union under the federal government, but the First and 14th Amendments are preventing that union. So instead of joining the state with the church, they are advocating for the union to be with the local Christian religious organizations and the local government, state laws. Let's listen to Vice President J.D. Vance on how to make this work without violating the First and 14th Amendments.
Point, and I want to just make sure that everybody's kind of on the same page here. So if you go back to the First Amendment, it doesn't say separation of church and state. It says Congress shall make no law respecting an establishment of religion. But if you go back to the founding time, there were actually a number of states that had formally recognized churches. So there was the Anglican Church of Virginia. That was the official state church of Virginia. Maryland at the time was the only majority Catholic colony, or at least had a significant Catholic representation of the original 13 colonies. There's a lot there. And yes, I do think that what happened is the Supreme Court interpreted Congress shall make no law respecting an establishment of religion to effectively throw the church out of every public space at the federal, state, and local level. I think it was a terrible mistake, and we're still paying for the consequences of it today. But and I think this is your point, if you were to undo that, if you were to get back to a system actually meant by the founders where Congress is not setting up an established religion, but people in their local communities can kind of do whatever it is that they want to do, I think that would be a better system than what we have today. But I think the most important principle that we have got to remember is you do not have to completely kick God out of the public square, which is what we've done in modern America. It's not what the founders wanted. It's not good for the United States of America. And anybody who tells you it's required by the Constitution is lying to you. Thank you.
First Amendment started in 1791, stated, Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble, and to petition the government for a redress of grievances. Summary of the 5 protections in the First Amendment. Religion. No government established religion. Government cannot interfere with free religious practice. Speech. You can speak your beliefs without government punishment. Press, news, media, and individuals can publish freely. Assembly. You can gather peacefully. Petition. You can challenge or criticize the government. The First Amendment and Sunday laws. What you need to know. How America's founding principles collide with modern proposals for religious legislation. 1. The First Amendment, the shield of American freedom. What if the government could tell you when or how to worship? The First Amendment exists precisely to prevent this. It contains 2 major protections regarding religion. A. No government religion. Congress shall make no law respecting an establishment of religion. This means the U.S. government cannot favor one religion over another, enforce religious practices, pass religious laws, promote a specific doctrine. B. No interference with worship, or prohibiting the free exercise thereof. This means you are free to worship or not worship. The government cannot punish people for practicing their faith. Your beliefs and religious observances are protected. Together, These two clauses force the government to remain neutral, neither forcing religion nor preventing it. 2. Sunday laws, where faith and government collide. Can the government tell the whole nation to rest on Sunday? Historically, a Sunday law refers to requiring Sunday rest, penalizing Sunday work, encouraging or forcing church attendance. Why this is a constitutional red flag? A law requiring religious worship or church attendance would directly violate the First Amendment because it establishes a religious doctrine, privileges Christianity's traditional day of worship, forces religious behavior. However, courts have permitted neutral rest day laws if they are tied to secular reasons such as worker health, public welfare, family rest. But once a law's purpose becomes religious, it crosses into unconstitutional territory. 3. Project 2025's Sabbath rest proposal, a constitutional tension point. When a policy document quotes God ordained the Sabbath, what does that mean for constitutional limits? Project 2025's mandate for leadership contains a section titled Sabbath Rest, proposing a national day of rest, Sunday as the default Sabbath, extra pay time and a half for working on that day, a justification stating, God ordained the Sabbath. Why this raises First Amendment concerns. Problem 1. Religious language. Using religious doctrine, God ordained the Sabbath, indicates a religious purpose, not a secular one. Problem 2. Defaulting to Sunday. Sunday is the traditional Christian day of worship. Giving it special legal status can be seen as favoring Christianity, indirectly establishing religion, pressuring people toward Christian practice. Problem 3. Burden on other worshippers. Non-Sunday observers, Sabbath keepers, Jews, Muslims, others, would have to prove their religious conviction to avoid the Sunday standard, a problem for the Free Exercise Clause. The government cannot evaluate someone's sincerity of belief without violating religious liberty. 4. Would this survive in court? Could a national Sabbath rest become law, or would the Constitution strike it down? Most legal experts conclude that the Project 2025 proposal would face major constitutional challenges because a. It mixes theology with federal law. The courts have consistently rejected laws that rely on religious doctrine as their justification. B. It privileges the Christian Sabbath. This conflicts with the Establishment Clause. C. It disadvantages minority religions. That violates the Free Exercise Clause. D. It resembles historical Sunday laws. Many of those were struck down unless they had purely secular justification. If enacted, this proposal would almost certainly be challenged immediately, and very likely overturned. 5. Does Project 2025 call for mandatory worship? Is this a step toward a national Sunday worship law? Officially, no. The document does not state, attend church on Sunday. You must worship. Sunday worship is mandatory. Focuses on rest, not religious services. However, the combination of religious justification, God ordained the Sabbath, Sunday as the default rest day, federal level enforcement, and historical patterns, makes many observers worry that it could be a foundational precedent for future religious legislation. 6. What the First Amendment ultimately protects you from. The Constitution draws a line, and it's brighter than many people realize. The First Amendment forbids the government from creating religious laws, establishing a national religion, requiring worship, mandating Sunday observance, favoring one religious holy day over another, punishing people for observing a different Sabbath, using theological doctrine as the basis for civil law. Any proposal from Project 2025 or elsewhere that uses religion instead of secular reasoning to craft federal law is on dangerous constitutional ground. Why your free speech and religious freedom apply to both federal and state governments. 1. Before the 14th Amendment, the First Amendment applied only to the federal government. Did you know the Bill of Rights originally did not protect you from your state government? When the Constitution was first written, the First Amendment applied only to Congress. States were not required to respect free speech or religious freedom. A state could pass a law punishing speech, a law forcing religious observance, a law banning a church, and it did not violate the U.S. Constitution at that time. 2. The 14th Amendment changed everything. The 14th Amendment made the Bill of Rights apply to all 50 states. Once ratified in 1868, the 14th Amendment added powerful protections: Due Process Clause, Equal Protection Clause, Privileges or Immunities Clause. The Supreme Court used the Due Process Clause to incorporate the Bill of Rights, meaning it forced states to obey them. This process is known as incorporation. 3. The 14th Amendment incorporates the First Amendment. This means states cannot violate your First Amendment rights. A state legislature cannot force a religion, ban a religion, restrict preaching, control church attendance, silence free speech, ban peaceful assembly, punish the press, block petitions against the government. The 14th Amendment makes all of these unconstitutional at the state level. 4. Why this matters for religious freedom today? Because of the 14th Amendment, your religious freedom is protected in every corner of America, not just in Washington. Thanks to the 14th Amendment, states cannot enforce religious laws like Sunday worship laws. States cannot impose one religion over another. States cannot punish you for your beliefs. States must provide equal protection for all faiths. Both the Establishment Clause and Free Exercise Clause of the First Amendment now bind state governments, local governments, public schools, state agencies, police departments. This is why state-level religious coercion would violate the Constitution. 5. Examples of 14th plus First Amendment working together. A. Mandatory religious observance. Unconstitutional. A state cannot require Sunday worship, prayer in schools, attendance at a particular church. B. State religious discrimination. Unconstitutional. States cannot ban certain denominations, punish Sabbath observers, promote a state religion. C. Free speech protections. States cannot arrest you for peaceful speech, censor the press, ban peaceful protests. All of these protections exist because the 14th Amendment forces states to obey the First Amendment. 6. Bottom line, the 14th Amendment is the bridge that carries First Amendment rights to your doorstep. Without the 14th Amendment, states could control religion, states could restrict speech, states could enforce their own worship laws, states could favor one religion. The First Amendment gives you freedom, and the 14th Amendment makes sure every state must respect that freedom. Together, they ensure no forced worship, no religious discrimination, no suppression of speech, and no government control over conscience. This combination is the backbone of American liberty.
If the First and 14th Amendments gave the citizens of the United States of America this backbone of liberty, why did some states pass Sunday blue laws and the Constitution upheld them?
The earliest Sunday blue laws, or blue laws, were enacted in the United States, and how courts have upheld them without necessarily violating the Constitution. When were the first Sunday blue laws enacted? Some of the very first laws requiring Sunday worship and restricting activities on Sunday in America were passed by Virginia Colony in the early 1600s. One source says a law in 1610 required colonists' attendance by all colonists at both morning and afternoon worship services on Sundays. The Oklahoma Encyclopedia of History and Culture states, the first blue law in the present United States was enacted in the colony of Virginia in 1610. These colonial laws had strong religious origins, for example, requiring church attendance, looking to keep the Sabbath holy under Puritan influence. Over time they evolved into Sunday laws regulating commercial activity, rest, etc., rather than purely worship mandates. How these laws were upheld without being struck down as unconstitutional, even though the origin of many blue laws was religious. The U.S. Supreme Court has upheld certain Sunday or rest day laws under the Constitution because of how they were presented and the secular purposes attributed to them. Here's how the legal reasoning works. 1. Secular purpose test. A key decision is McGowan v. Maryland 1961. The court held that Maryland's Sunday closing law did not violate the free exercise or establishment clauses of the First Amendment. The court emphasized that while the law had religious roots, its modern purpose was secular, to provide a uniform day of rest, promote recreation, family time, and social stability. Because the law was framed and functioned primarily as a secular regulation rest, commerce, workers, it could survive constitutional challenge, even though the day chosen happened to be Sunday. 2. Neutral application. The laws must apply neutrally and not target a specific religious group or compel religious observance. For example, they cannot force people to attend worship or penalize someone for observing a different Sabbath. In Braunfeld v. Brown, the court acknowledged burdens on some Sabbath keepers, but still upheld the law under certain conditions. 3. Historical recognition of state power to regulate commerce and labor. The court recognized that states historically had authority to regulate commerce, labor conditions, business hours, and public health or welfare. Sunday laws, when framed under those powers rather than strictly as religious mandates, fit within that tradition. Thus, when the state says, "We're providing a day of rest," rather than, "We're enforcing church attendance," the law is more likely to be constitutional. 4. No establishment of a religion. The court requires that the law not establish a particular religion or force religious observance. As long as the law does not mandate worship, pray, or discrimination against other religions, it has a stronger chance of being upheld. In McGowan, Chief Justice Earl Warren wrote that the fact the day chosen is Sunday does not bar the state from achieving a secular purpose. Summary: the earliest Sunday blue laws in the U.S. date back to colonial times Virginia around 1610 and were heavily religious in origin. Over time, many states kept Sunday laws, blue laws restricting commerce or business on Sundays. The U.S. Supreme Court has upheld such laws not because they promote religious worship, but because they serve secular ends, for example, rest, uniformity, labor, regulation, and apply neutrally. The key constitutional pivot is, the law must be justified by secular purpose, not primarily religious compulsion, must be applied neutrally, and must not establish religion or force worship. What happens when Sabbath keepers, Saturday observers, do not want to rest on Sunday, but want to work instead? The situation has already been tested in the United States many times, especially by Seventh-day Adventist Jews, some Church of God groups, others who keep Saturday as the biblical Sabbath. Below is exactly how the law handles this. 1. Under current constitutional law, the government cannot force you to worship on Sunday. The First Amendment religious freedom plus the 14th Amendment states must respect those freedoms means no one can force Sunday worship. No one can punish you for working on Sunday. No one can require you to rest for religious reasons. As long as your Sunday rest is framed as religious, the law cannot compel it. 2. But Sunday rest laws have sometimes required rest even for Saturday keepers. Historically, many Sunday blue laws required stores to close, businesses to stop operating, certain work to halt on Sunday, even for Sabbath keepers who rested on Saturday. Why did the Supreme Court allow this? Because states argued the purpose was secular, points to a uniform weekly day of rest, not religious worship, not forcing Christianity, not requiring anyone to go to church. That's how Sunday rest laws survived past court cases. 3. If a modern Sunday rest law passed and you wanted to work instead, here is what would legally happen. A. You could not be forced to worship. You cannot be required to attend church, participate in religious activity, pray, observe Sunday as holy, treat it as a religious Sabbath. This is absolutely protected. B. But you might still be limited from certain kinds of work. If the law is framed as economic regulation, commerce, labor rights, overtime rules, justified in secular terms, health, family time, social rest, applied equally to all groups, then the courts could uphold it. meaning you could be told you cannot open your business or you cannot work certain hours, even if your religion already requires Saturday rest. This happened historically to many Adventists and Jews. 4. Does the Constitution protect you from being double-rested? Saturday keepers have argued, if I rest on Saturday and Sunday, I lose income and opportunity compared to Sunday keepers. That is discrimination. The Supreme Court responded, it recognizes the burden, but says the law is constitutional if the purpose is secular. This was decided in Braunfeld v. Brown 1961. Jewish businessmen challenged Sunday laws and lost. 5. However, modern courts lean more strongly toward religious accommodation. Recent decades have seen stronger protection for Sabbath accommodation, religious practice, workplace accommodations, avoiding discrimination against minority faiths. Today, a strict Sunday rest law would face 1. Street Amendment challenges, 14th Amendment equal protection challenges, Civil Rights Act, religious accommodation requirements. Modern courts are far less likely to uphold a law that forces a second rest day, especially if it disadvantages religious minorities. It imposes economic hardship. It appears religiously motivated. This makes forced Sunday rest far weaker legally today than in June 1961. What if the Sunday law is openly religious? For example, God ordained Sunday. Then the law becomes unconstitutional immediately. Any law that uses Christian language, mandates Sunday as a holy day, enforces a religious commandment, quotes scripture, would violate the Establishment Clause, the Free Exercise Clause, equal protection, historical precedent. It would be struck down very quickly. 7. Summary: what happens if you refuse Sunday rest legally? You cannot be forced to worship on Sunday. You cannot be forced to keep Sunday as a holy day. You cannot be punished for your religious beliefs. You must be allowed to practice Saturday Sabbath. But if a secular Sunday rest from work law is passed, you might still be restricted from working on Sunday even if you rest on Saturday. However, modern courts are much more protective of minority religions. A new Sunday rest law would face major legal challenges and likely be ruled unconstitutional if it disadvantages Saturday keepers. It uses religious justification. It lacks a neutral secular purpose.
Since the First and 14th Amendments prevent a state religion, then to achieve a state religion, the USA has to abolish the Constitution and put in a new one. Is that possible?
Even the president can't just hit the reset button on America. Is that correct? Answer: no. Abolishing the Constitution by force or decree is A. unconstitutional, B. illegal, C. void, and against every principle of American governance. The Constitution contains its own instructions for how to change it, and no shortcut is allowed. Could a state religion happen informally without rewriting the Constitution? You don't have to tear down a house to change what happens inside it. This is where history becomes fascinating. Other countries have strengthened religious nationalism, enforced religious norms, pressured minorities, passed religious-leaning laws, without ever rewriting their constitutions. How? By using new court interpretations, executive orders, national emergencies, laws framed as public good, and cultural pressure. In such cases, the Constitution stays on paper, but its application gradually changes. So yes, a society can drift toward a practical state religion without legally abolishing the Constitution. So, what is the real answer? How can the country have a state religion? Answer: the text may stay the same, but how it's interpreted determines how it lives. Legally, a true state religion would require a constitutional amendment. Practically, religious nationalism can grow through political movements, reinterpretation of laws, cultural shifts, policy changes, even without rewriting the Constitution. This is why constitutional literacy is so important. It protects the spirit of freedom, not just the words. Nations throughout history have moved from religious freedom to religious pressure, and eventually to a state religion. This pattern repeats again and again in different cultures, eras, and governments. This is the seven-stage pattern that historians, theologians, and political scholars all recognize when nations gradually moved into having a state religion. The repeating pattern that appears in ancient empires, medieval kingdoms, colonial powers, and modern nations. 1. A period of broad religious freedom, or at least tolerance. It always begins quietly with freedom that feels too secure to lose. Most societies begin with high diversity, little central control of religion, many beliefs coexisting, individual liberty to worship. For example, the early Roman Republic, the early American colonies, pre-Constantine Roman Empire, pre-Islamic Persia, and early India. Ashoka's initial model. During this phase, the state does not enforce religious practice, but this phase is almost always temporary. A change uses the pattern from the Hegelian dialectic model, create chaos, and suggest a temporary solution that will eventually become permanent. 2. Rising social or moral tension. People grow anxious, and when people fear, they seek unity. The common triggers are economic instability, war, cultural fragmentation, political conflict, moral panic, or rapid social changes. In moments of uncertainty, society begins asking for solutions, such as, what is happening to our nation? Where is our unity? Where is our identity? How do we restore order? This anxiety becomes the seed for religious nationalism. 3. A majority religion gains cultural dominance. Long before religion becomes law, it becomes the culture. One religious group often becomes the majority, and has the cultural standard, the true national identity. However, this group may not yet control the government, but it increasingly controls education, media, norms, language, and national holidays. Minority religions remain free, but will begin to feel pressure. For examples, Christianity rising in the 3rd–4th century Roman Empire, the Lutheranism in Scandinavia, Anglicanism in England, and Hindu nationalism in modern India. 4. Politicians begin using religion for political power. When faith becomes a tool, freedom begins to bend. This is one of the most consistent historical patterns. Leaders begin to quote sacred texts, use religious symbolism, appeal to the majority religion, promise national restoration, and label opponents as immoral or ungodly, and claim divine support for political power. Religion stops being spiritual and becomes a political currency. This stage prepares the public for religious legislation. For examples, Constantine's use of Christianity in Rome, the Tudor monarchy in England, Islamic political parties in modern Middle East, Buddhist nationalism in Sri Lanka and Myanmar. 5. Laws begin to favor the majority religion slowly and quietly. It rarely starts with force. It starts with favors. This stage includes laws that recognize the majority religion's holidays. It gives tax benefits to majority religious institutions, encourage conformity for social good, restrict minority practices indirectly, use moral language to justify legislation, and blend religion with national values. This is not yet state religion, but it is a soft establishment. For examples, Roman Sunday laws under Constantine 321 AD, English Test Acts 1673, Spanish Catholic Privileges 1400-1700s, modern national culture laws around religion. This is where religious freedom begins to erode slowly, almost imperceptibly. 6. Religious laws become enforced as moral or civic duty. When obedience is tied to patriotism, resistance becomes treason. This is the turning point. Laws begin to say, good citizens follow this religious practice. This religious value is part of national identity. Participating shows loyalty to the nation, or non-participation harms social unity. At this point, religious minorities begin to face social pressure, financial disadvantage, reduced employment opportunities, restrictions on religious practice, or accusations of being unpatriotic. The law may still be framed as public safety, public morality, national unity, but the religious undertones are undeniable. 7. The majority religion becomes the state religion formally, or practically, by the time the state religion is declared. The culture has already accepted it. This stage can happen in two ways. A. Formal establishment. The constitution is changed or replaced, and the religion becomes legally official. For examples, Christianity in the Roman Empire 380 AD, Anglicanism in England 1534, Catholicism in medieval Spain, Islam in many Middle Eastern constitutions, and Buddhism in certain Asian constitutions. B. De facto establishment. The constitution stays the same, but the courts, police, schools, government, and the culture all operate as if one religion is the national faith. For examples, Russia Orthodox favoritism, India Hindu nationalist pressure, and some modern European states. This second version B is the most common today. The 7-stage pattern always repeats the same way, no matter the nation or era. The slide goes like this: A. Freedom, peace, and quiet. B. Anxiety or chaos. C. Cultural religious dominance. D. Political religion. E. Religious favoritism and laws. F. Religious duty as civic duty. G. Finally, state religion. Formal or informal. This pattern is why the United States Constitution created the First Amendment: no establishment, and the 14th Amendment states must obey it. These two protections were designed to break the historical cycle of a state and church union.